Good morning. Thursday's District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, gum chewing, or reading any material. Thank you.
Thank you. This is case number 24-169-217. This is Velocity Investments versus Camilla Anderson. The matter is before the court, set on for a pretrial conference. Court previously issued a scheduling order regarding this matter. Your appearance for Velocity, please.
Yes, Your Honor. Chris Royce, P49102.
Thank you, Mr. Royce, and good morning to you. I'm looking for Camilla Anderson. If you're on the Zoom, Ms. Anderson, please say something at this time.
Yes, sir, I'm here.
All right, and good morning to you, Ms. Anderson. All right, counsel, as an officer of the court, give me an update on where things are at this point, sir.
Yes, Your Honor. I have not spoken with Ms. Anderson, although I see in her answer she made an offer which I believe will resolve the case. I apologize. This is the first time I'm seeing a copy of her answer. I'm going to submit that. My suspicion is it will be accepted and we can submit closing documents.
All right. You want to take a moment in a breakout room to go over that?
Sure, absolutely.
So, Ms. Anderson, I'm going to send you to a breakout room with Mr. Royce to talk about some things that seem to be pertinent to this matter. So you're going to get a notification right now.
Okay.
There it is. So Royce, you're receiving that same notification.
Perfect. Thank you.
All right, then just come back in afterwards. All right, the court now calls case number 24-241524. This is Beverly Parker versus Princeton Management. The matter is before the court. Looks like I set this up as a pretrial conference date, although it looks like there was a request for a subpoena. That request was denied. All right, any counsel involved in this matter, your appearance at this time, please.
Morning, Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor. I'm the defendant. I apologize. The defendant.
Thank you, Ms. Coleman. Good morning to you. All right, do I have Beverly Parker on the Zoom?
Yes, I am here.
All right, thank you, Ms. Parker. Good morning to you. All right, Madam Counsel, as an officer of this court, update me on things as you understand them at this time, please.
Well, there was a motion to compel discovery, but we never received the request for discovery. And I don't believe this court did either. So that's, I believe, one of the items that's up for today. We're happy to provide the discovery now that we have a copy of what she's looking for. And that's my update.
All right, on the 30th of April of 2025, I did deny a motion for subpoena, and I indicated that discovery issues would be addressed on today's date. So, Madam Counsel, you're saying that any discovery that has been requested by Ms. Parker, that you're prepared to tender that discovery. Is that correct, ma'am?
That's correct.
All right, Ms. Parker, good morning to you again. I know that you brought a motion regarding the subpoena, and you've asked that certain information that you're requesting be turned over to you. So the other side, they've agreed to do so. We set a date in that regard. Anything else you wanted to bring to the court's attention at this time, Ms. Parker?
No, but I don't understand why they didn't say, they're saying they didn't receive it, because I have proof that it was sent and it was signed for. And I heard nothing from them at any point.
All right. Well, I mean, I've seen stranger things occur. The is that they're prepared to give you, provide the information you requested, and that makes sense. I'll order that be done. Have the parties talked about this in any way, Madam Council, in terms of seeing whether there are points of resolution? I know the claim is in the nature of some $2,300 to $2,400. Has there been any discussions in that regard?
No, I think she's got to look at our response to discovery, and we have to look at her response to discovery before those can before those negotiations can happen, Your Honor. We're still waiting for her responses to discovery.
All right.
Whose responses? Mine?
Yeah.
I haven't received anything from you.
Okay. Well, then that's a problem because our records show that the discovery was sent to you. So maybe do you have an email address I could send those to?
I did, and on the letter I sent for discovery, I put my email address on there, so I'm not sure.
As I mentioned before, this is something that comes up sometimes in discovery. So what I want to do is set a date for the exchange of the information. And I'm going to put the two of you in a breakout room just to make sure that the addresses, locations for sending any discovery items are exchanged properly, because obviously mutually the parties say, well, I sent it and they didn't get it, and they said that I didn't get it. So perhaps we can close the loop on that aspect of it. So I'm looking at,
Okay.
I'm looking adjourning this about 30 days out, and I'll bring it back for a review at that time. So that's going to put us, just 1 second.
Okay.
Madam Clerk, can we do it on the 18th?
July 18th?
June 18th.
Yes.
So June 18th, I'm going to have the parties back for this pre-trial conference. I'll order that the answers to the interrogatories or the provision of the information requested mutually, that information be submitted not later than the 11th of June. The 11th of June. Obviously, if you can get it in before then, I'll give you some time to make sure the parties have changed that information. Let's see. Actually, I'll give you to the 13th. The 13th of June to supply the information mutually, and then I'll review the matter on the 18th. 18th at 9:30. You have until the 13th of June to make sure that you exchange the information. So now you'll get a notice of that new date. That is again the 18th of June at 9:30 a.m. All right.
Okay. All right.
Ms. Coleman, I'm sorry, you said something, Ms. Coleman.
I didn't say anything, Your Honor. Maybe Miss Parker said something.
No, thank you.
All right, thank you. And I'm going to send you to the breakout room now, just so that you can mutually tighten any issues regarding discovery or addresses and things of the like.
Okay.
Can we leave after we've met, or do we need to come back?
No, you don't need to come back in the courtroom. You got your date, the 18th at 9:30, and the cutoff date for submitting the discovery, the 13th of June.
Okay, thank you so much.
Thank you.
Just click into the breakout room. All right, the court calls case number 25-140-426. This is Bank of America versus Jalen Garland. The matter is before the court, set on for a status conference. This is the first hearing regarding this matter. Your appearance for the plaintiff, Bank of America, please.
Good morning, Judge Coleman. Sazan Barta, P65425.
All right, thank you, Mr. Varda. Good morning to you, sir. I'm looking for Jalen Garland. If you're on the Zoom, say something at this time.
Yes, good morning, Your Honor. Jalen Garland.
Thank you, Mr. Garland. Good morning to you, sir. All right, counsel, I see that this is a claim alleging some $4,600 as damages related to what seems to have been I believe a credit card agreement or something along those lines. All right, update me on where things are, sir.
Your Honor, you are correct. This is a initial pretrial. I think plaintiff's going to probably file a motion for summary disposition at some point. I'm hoping we can resolve it with Mr. Garland. So I think at this point, we just need a pretrial order, maybe set it down the road 60 or 90 days. And then if you could please put Mr. Garland and I into a breakout room so we can discuss the matter.
All right, Mr. Garland, the next step, of course, is for the court to set up a pretrial schedule. And it's at this point, the parties try to find out whether or not they're able to come together and reach some type of agreement. So I'm going to do a couple of things. One, I'm going to set up a pretrial scheduling order and give you a return date. I'll give 60 days of discovery on that pretrial order, and that will bring the parties back before the court on the 15th of July. So 7/15/25 would be the next action date. You'll get that date in the scheduling order. Will be in as well. So 7/15/25 at 9:30 a.m. And so that order allows for discovery. That means the exchange of information between the parties. And if you put something in writing or requested documents, et cetera, then the parties are required to mutually submit the same where the request is relevant and allowed by the court. So that's the first step that we're going to take in this regard. You get the paperwork in 2 days in mail. The second thing I'm going to do is I'm going to put the two of you in the breakout room now with hope that maybe you can talk about this and find out if there is some common ground where the matter might be resolved. So I'm going to send you the notification now, the electronic notification, and that will give you an opportunity to go to a breakout room. And once you're done in the breakout room, you're free to leave. And again, you'll be getting paperwork in the mail from me in the next couple of days. All right. So good day to both. Your notification should be on your device now. Go ahead to the breakout room.
Thank you.
Thank you. Good day. All right, the court now calls case number 2514-1215. That is, and I'm coming right to you, Mr. Royce, in just a moment. This is Gateway Financial Solutions versus Devon Sampson. The matter is before the court on the filing of a civil complaint, of course, and there's the answer that has been filed. It's just set for a status conference. And let's see, do I have 1 second. Counsel for Gateway, your appearance, please.
Yes, good morning, Your Honor. Zachary Schisler appearing on behalf of the plaintiff. P number 82247.
Thank you, Mr. Schisler. Good morning to you, sir. All right, I'm looking for Sampson. Last name is Sampson. If you're on the Zoom, please say something at this time. It looks like Devon J. Sampson, a person living on Binder Street in Detroit. All right, the record should reflect that a notice did go to Mr. or the defendant last name Sampson at the address on Binder Street as provided in defendant's answer. That notice went out on the 6th of March of 2025, indicating that this date will be a date for a status conference hearing. Counsel, have you had any contact with Mr. Or that person Sampson?
Have not.
All right, it looks like then that the defendant has failed to appear regarding this matter. Counsel, you may proceed accordingly.
Yes, Your Honor. I would ask for both the non-appearance of the defendant, but also the content of the defendant's answer, where he marked that he agreed with paragraphs 1, 2, 3, 5, and 6, and just does not know in 4 and 7. So I don't think he's truly really answered the complaint in a satisfactory manner, and he hasn't appeared today. So I would ask that a default judgment be entered. I'd be willing to submit that under the 7-day rule to give him another opportunity to object and appear.
All right, thank you, counsel. The court will find that the defendant is in default on the failure to appear. And the plaintiff may proceed with the offering of judgment on that default. And court will review and enter the order when submitted. And you can use the 7-day rule as a way to approach that. Thank you, counsel.
Thank you.
All right, and we're back on the record regarding the Velocity versus Anderson matter. And I know the parties did go to a breakout regarding this matter. Thank you, Mr. Royce. I know that you're back. Ms. Anderson, I see that you're back as well. And Mr. Royce, you may proceed to update me regarding the subjects 92172.
Yes, Your Honor. I confirmed that the offer is still valid. This is a brand new client for our firm. So I don't know what my authority is. This is something that I think that would be accepted in by virtually any creditor. So I am checking, and I should have an answer probably by tomorrow. But I think that if this matter was just adjourned or rescheduled for a final pretrial one more time, it will very likely be resolved.
Ms. Anderson, this discussion makes sense to you, ma'am?
Yes, sir.
All right, so I'm going to go ahead and adjourn this matter. And I'm going to set it over for the 29th of May. Let's see if we can bring it back in. And I'm going to set it for a review. And let's see what the parties are on 5/29/25 at 9:30. Of course, if you get it worked out, then you would just submit the paperwork. But if it hasn't been worked out, then I'm getting the parties to be here on 5/29/25 at 9:30, and then we'll set up a schedule on the case and go forward from there.
Thank you, Your Honor.
Perfect. Thank you.
Thank you, Ms. Henderson. I'll see you at that time while I anticipate the paperwork. Good day to you.
Awesome. Good day.